again, welcome.
Thank you.
You talked about the principle of judicial restraint, which is to allow the legislator and the executive more freedom to formulate laws and policies. How will you align that with judicial activism or adventurous tendencies by the courts, especially in the court where you intend to be the president?
I did mention, Commissioner Warsame, that I don't subscribe to extreme judicial activism. And at the same time, I don't subscribe to total restraint and conservative interpretation of the Constitution. I subscribe to the philosophy whereby, where it is clear there is room for purposive interpretation, then a court is required to and should proceed along the path of interpreting the article in question in order to make, in fact, they say the purposive is in order to give effect to whatever the Constitution was trying to provide for.
Now, you are a criminal lawyer, of course, being the DPP.
I practice criminal law.
Yes.
I'm not a criminal lawyer.
Yes. Thank you for the correction. You have read maybe the Murgor case,
Yes.
which said at section 204 of the Penal Code, insofar as it provides for a mandatory sentence, that sentence is unconstitutional. And the court said, gave some direction that the Attorney General, the DPP, the Speaker of the National Assembly and the Senate to do certain things. Would you consider that decision to be an aggression on the part of Parliament and the people of Kenya? Because the Penal Code under 204, as read together with 203, 296(2) of the Penal Code, the one which deals with robbery with violence, and treason. Those are capital, they provide for capital punishment. Under the Constitution, which our Constitution, you termed it as progressive, Article 26, I think so, either 26 or 25, provides for death penalty, provided it is prescribed under the law. What is your view?
About Murgor or about what the Attorney General was
The
required to?
The Murgor case.
I have no qualms or problems with the final result in the Murgor case. I think it is sound reasoning.
In terms of its import,
yes,
and how it has been misused to even provide for other offenses, like the Sexual Offenses Act, and you know, for example, 2962. What is your view?
Now, my Lord, with your permission, and I will not name names, but you and I might know what we're talking about. There was once a case where there was a fight and it resulted in a death, and there were two individuals involved. One pulled the trigger, one might have been involved in an earlier altercation. And I recall in that decision, the judge said, since somehow these two issues are connected, without the fight, the subsequent pulling of the trigger would not have occurred. I find both of them, the judge found both of them guilty. Now, Murgor specifically dealt with that kind of case. The culpability, the responsibility of both actors is completely different. When the first gentleman was having his verbal altercation, he could not have imagined that it would have ended up with his friend doing something, pulling a gun and pulling a trigger. So to that extent, I understand the persuasive reasoning of the Supreme Court in that regard, where there should be qualification, there should be scope for determining, for punishing responsibility by way of the sentence to be meted out. When the second part of it, or the other part of that, when you mentioned it, when the court requests that the matters be placed before the Attorney General to consider legislation, amendment of the legislation, I also have no quarrel with that. Now, I'm coming to other types of acts. I think every act should be looked at on its own and what it is intended to do. The case of murder, it was simply a case of the old teachings in several holy books. Eye for an eye, you kill, you are killed. But over time, that qualification is being made by society. The death penalty is being abolished and so on. So there's a movement in a certain direction. But in the case of other statutes, I may have some reservation. For example, I didn't mention it, Madam Chair. I have been involved in wildlife conservation, in particular, fight against trying to stop poaching of elephants. Some years ago, I was the chairman of a group that very successfully agitated and ensured that was done. And in the course of all that, we dealt with, the levels of involvement in handling game trophies, so that if you are found with so much, you are deemed to be this and deemed to be that. And the only way that it could actually be a deterrent is, and we're now not talking about murder, which sometimes is simply a crime of passion, and it's a series of events that end up in death. When you are dealing with things like narcotics, when you are dealing with things like game trophies, the message that the legislator wanted to send out is, if you handle an elephant tusk in a certain way, you are guilty of a certain offense which provides for a minimum. So there is where I personally would find some difficulty. So I would prefer, if there's any question regarding a particular statute, I would okay. Express myself.
Okay. Mm-hmm. Under Article 143 of the Constitution, the President of the Republic of Kenya enjoys immunity both from criminal and civil cases during his tenure. In one of the decisions in the Olekewa case, we said, if the president decides to sack, for example, 20 judges on the same day without following the correct procedure, he does not enjoy immunity or protection. What is your view in terms of criminal prosecution or civil prosecution of a sitting president in terms of the article? What does the article talk about? Actual things which the article is talking about. In your interpretation as the president of the Supreme Court, CJ Murgor.
Now, my Lord, I see a situation arising.
And you have the option not to answer. You can say pass.
I know I want to answer it by not answering. In this way, when you put forward a hypothetical situation like that, I think it's unfair to a person who you consider may end up in the Supreme Court. Because should he be faced with such a situation, he would have already expressed his view. And it would be the first order of business to disqualify that judge. So these hypothetical situations have their examples that are posed as questions, have their dangers. So I would request that it is...
Can the president sue personally? I'm leading to other questions which will come. During his period as president of the Republic of Kenya, can he sue personally?
I think by the same vein, that's exactly the same situation is arising. If he were to sue personally, if the question arose as to whether he can, it would be a justiciable issue which would end up coming up to the courts. So I would prefer not to also express my view.
and I want you to express your view. Does the deputy president enjoy the same immunity under 143?
Again.
And I want your view. I want you to answer, because
If
the reason why we are here, we want you to know your views. We are not saying there is anything wrong with expressing your views.
there is absolutely everything wrong in expressing a view about a matter that may become a reality in due course, for whatever reason, or not a reality. If I was interviewing for Director of Public Prosecutions, I might have answered your question. But I am not interviewing for the Director of Public Prosecutions.
Okay.
I am now going to sit as a judge. I have no view that is worth putting out, because I must be seen to have a blank mind when I will hear anyone in such a dispute, on such a question.
Senior counsel, I'm a judge. I was involved in the Olekiwa case, and I expressed my view. You can sue the president if there is a clear and dire constitutional violations in his personal name.
How did you express your view, my lord?
In the Olekiwa case.
As a judge?
As a judge.
And I assure you, when
Yes.
that question comes before me,
Yes.
and I am a judge, I will express my view.
Okay.
Yes.
Now, under Article 144 and 145, the president can be removed on grounds of incapacity.
Yes. Yes.
Under Article 147, one of the functions of the deputy president is to act as a president when the president is temporarily incapacitated. If there is a conflict and the deputy president says, you want to start 144, but I am the deputy president of the Republic of Kenya. Therefore, 144 cannot kick in during my term. How will you rule?
How can I tell you how I will rule? You might make me the Chief Justice. How can I tell you how I will rule in advance?
Okay.
If you were confronted with the same Olekeiwa decision before you had ruled, would you have told the whole world what you would have done?
You see, you are on that chair,
It's
and you are the one who is seeking to be the president.
My
of
lord,
the Supreme-
I request your pardon.
I have no problem.
I am saying
I have no problem.
I am saying the
Okay.
question is, I have asked it by way of asking a question.
Yes.
I've answered it by way of asking a question.
Okay. Under Article 144 and 145, which involves the removal of the president, if the president is removed under one of those articles, is he entitled to approach the Supreme Court? And how will you deal with that case? And that's why I was asking you the immunity of the president under 143. Because this one is his personal, because he's removed as the president of the Republic of Kenya under 144 and 145. Can he now approach the Supreme Court in his personal name, or the decision of the tribunal and the parliament and the Senate is final, according to you?
My lord, you are asking me to express a view on jurisdiction.
Okay.
If I would...
Let's go to the next question.
Yes,
Yes.
I can't.
Yes.
Yes, yes.
Article 146(2)(b provides, in the event of a vacancy in the office of the president, the DP takes the office. In the event the DP is not available, the Speaker of the National Assembly. But the Constitution is silent. In the event the Speaker of the National Assembly is not available, who will be our president?
My lord, on a light note, I was reading it, I saw the gap, and I said to myself, it might be the Chief Justice. And in the absence of the Chief Justice, it would be the Deputy Chief Justice. And in the absence of the Deputy Chief Justice, the senior most... What am I saying? I cannot speculate. It says what it is. If it is a matter that is there is a gap in the law?
Senior counsel, you are right, because the first stop is the legislature. The third stop is the judiciary.
Yes, but those who drew up this constitution, those who are framing the laws now, those involved in amending the laws right now, those are the things they consider. The Chief Justice, the judge of the Court of Appeal, like you, the judges of the Supreme Court cannot go into that arena where they are filling in gaps in such a substantive manner.
Okay, and this is my last question. The question of review of punishment, of sentence, conditional pardon, substituting sentence is ordinarily reserved for the judiciary. Ordinarily reserved for the judiciary. Tell us one instance where the President of the Republic of Kenya can exercise judicial function.
In our law, it provides for presidential pardon.
Tell us one instance where our president can exercise judicial function as a sitting president.
I see what you're asking. You're saying he seems to be performing the judiciary function. Where do we perform?
I didn't say judiciary function, I said judicial function.
You have asked a question where you've said, show me one.
I said, tell us one instance where our president, the President of the Republic of Kenya, as a sitting head of the executive and the government, is allowed under the Constitution to exercise judicial function.
He doesn't exercise a judicial function. He just exercises his presidential powers.
I wish you well.
Thank you.
Under 33, Article 133, it's a judicial function. Thank you very much. I wish you well.
Thank you very much, Judge Wasame. Thank you, Senior Counsel. It's now the turn of Honorable Commissioner Justice Majaja to ask his question.
Thank you very much, Chair. Good morning, Senior Counsel. You presented 5 sample writings for consideration by the Commission. The first one, submissions in a case you argued.
If I may just, pardon me. Please permit me, Commissioner Wasame. Madam Chair.
Yes, sir, Senior Counsel.
He put an article of the Constitution on the table and then said, thank you very much. In fairness to me, I am looking at the article. At no point whatsoever under Article 133(1) is the President said to be exercising a judicial function. It might be his respectful view, but it is not worded so in the relevant article. Thank you.
Judge Wasame, do you want to respond or okay? Thank you. Thank you, Judge. Noted, Senior Counsel. Go ahead, Judge Majaja.
Thank you, Chair. Yes, Senior Counsel. Yes, you presented 5 written